Section 22, the Notice of Trustees Sale and Arizona's Foreclosure Clock. David has a date on the calendar now. Ashley sits across from David at his kitchen table and reads the Notice of Trustees Sale he received. This time, there is no guessing about whether David is simply behind on his mortgage. The document identifies the property and provides a date, time, and place for the proposed trustees' sale. David points to the date and asks, "So is that the day they foreclose on me?" Ashley knows enough now not to give him a casual answer. She calls Michael, sends him the notice, and begins verifying exactly where David is in the process. This is where foreclosure becomes very different from the ordinary contractual deadlines we studied earlier. David is no longer dealing only with the closing date in a purchase contract. He now has a statutory trustee sale timeline running against the property. The notice starts a very important clock. Under ARS Section 33-808, the trustee records a notice of trustee sale in the appropriate county recorder's office. The statute provides that the sale date identified in the notice must be no sooner than the 91st day after the notice is recorded. That wording is important. You will sometimes hear agents say, "Arizona foreclosure takes 90 days. That shorthand can create the wrong impression. An experienced Arizona agent should understand that the statute establishes specific requirements, and the actual notice should be reviewed, rather than calculating a client's deadline from something another agent said at an office meeting. For Ashley, the practical lesson is simple. Once she knows a notice of trustee sale has been recorded, the scheduled sale date becomes one of the most important dates in her transaction management system. The trustee doesn't just pick a date in secret. Arizona law contains multiple notice requirements surrounding the sale. ARS Section 33-808 addresses recording, posting, and publication. Among other requirements, a copy of the notice is generally posted at least 20 days before the sale, as prescribed by the statute, and the notice is published in a newspaper of general circulation once a week for 4 consecutive weeks, with the final publication not less than 10 days before the sale. ARS Section 33-809 contains additional mailing requirements, including notices to specified parties and persons with recorded interests. Why does this matter to a real estate agent? Because David may receive communications from several different sources, and he may not understand which document matters. Ashley needs to recognize a formal notice of trustee sale when she sees one. She doesn't need to become the trustee. She needs to recognize that the transaction has become urgent. So we're safe. A week later, Ashley receives a new offer on David's property. David is thrilled. Great, now they'll cancel the foreclosure. Ashley immediately corrects that assumption. Having a buyer does not itself cancel the trustee's sale. Opening escrow doesn't automatically cancel it. Submitting another short sale request doesn't automatically cancel it either. This is something an agent cannot afford to get wrong. Imagine Ashley tells David, "We have an offer, so don't worry about the trustee's sale." Everyone focuses on the short sale package while the statutory process continues in the background. That could become a disastrous mistake. Until Ashley receives reliable confirmation that the scheduled sale has been canceled, postponed, or otherwise affected through the appropriate process, she continues treating the scheduled date as real. Then David hears the sale was postponed. 2 weeks later, David calls Ashley excitedly. "My neighbor looked online and says the sale got postponed another month." Should Ashley erase the original date from her calendar and relax? No. ARS Section 33-810 permits a trustee sale to be postponed or continued. The person conducting the sale may announce the new date, time, and place by public declaration at the time and place last appointed for the sale. Under the statute, the new sale date must be a fixed date within 90 calendar days of the declaration. This creates an important practical issue. A postponed trustee sale may not involve the kind of entirely new notice process David expects. Ashley needs current, reliable information. A neighbor's internet search is not transaction management. The closer the date gets, the more dangerous guessing becomes. Michael gives Ashley another broker warning. The closer we get to that sale date, the less room you have for assumptions. Arizona law places enormous importance on timing when someone seeks to challenge a trustee's sale. ARS Section 33-808 and 33-811 contain significant provisions concerning objections and court relief before a scheduled sale. That is attorney territory. If David believes the foreclosure is improper, Ashley should not investigate the legal validity of the sale and announce whether the trustee can proceed. David needs qualified legal counsel, and he needs it promptly. An agent who tells a seller that foreclosure is illegal, so ignore the notice, may have just stepped far outside the appropriate role of a real estate licensee. David asks whether he still has any options. David looks at the calendar. The trustee's sale date is approaching, but it has not occurred. So am I already too late? Michael tells him not to assume that either. Depending on the facts and timing, Arizona law provides mechanisms that may be relevant before a trustee sale occurs. One of the most important concepts is reinstatement, and reinstatement raises a question many homeowners misunderstand. Does David have to pay off his entire mortgage to stop the default? Or might he be able to cure the delinquency under Arizona law? That's where we go next in Section 19, Reinstatement, Payoff, and Options Before the Trustee Sale. Online Discussion 1. David receives a notice of trustee sale showing a scheduled sale date. What should Ashley do with that information? Answer. Ashley should treat the scheduled sale date as a critical transaction deadline, obtain and retain the actual notice, involve her designated broker, and verify the current status through reliable sources. She should not assume that a listing, purchase offer, escrow, or short sale submission automatically stops the trustee sale process. 2. David tells Ashley that his neighbor says the trustee's sale was postponed. Should Ashley rely on that information? Answer. No. Arizona law permits trustee sales to be postponed or continued, but Ashley should verify the current sale status through an appropriate, reliable source rather than relying on informal information. Because postponement procedures can differ from what a consumer expects, accurate verification is particularly important. 3. David believes there is a legal defect in the trustee's sale and asks Ashley whether the sale is invalid. What should Ashley do? Answer. Ashley should not provide a legal opinion about the validity of the trustee's sale. She should immediately involve her designated broker and recommend that David consult a qualified Arizona attorney. The statutes contain significant deadlines concerning challenges to trustee sales, making timely legal advice especially important.